Hello, my name is Major Mike Webb, a former candidate for Arlington Public School Board, but currently preparing for oral argument for the United States Supreme Court, and a matter raised on appeal in the first filed and longest surviving litigation challenge to have been brought in the Commonwealth of Virginia against the facial coverings mandates, which are not technically masks, to clear up some misunderstanding, as many have described them, at least to a scientist. But for those not familiar with the legal system, believe it or not, as an appellate court, the Supreme Court does not decide a case like one would find in a trial court, perhaps in a movie. The Supreme Court does not do that, but only acts in a supervisory capacity for a final review. And it's not making many exciting movies about going before the Supreme Court, based upon assignments of error that have been preserved, generally by expressing objections. That's why you see that in the movies. I strenuously object during the lower court hearings and trial. A general rule for appellate review is that if an error requires review about the application of the law, the appellate court is not going to retry your case and examine all of the evidence, call all the witnesses, and all that stuff you see in the movie. But if the error involves a matter of fact, or even a mixture of fact and law, only then will the review be conducted, as they say, de novo, the Latin phrase used by attorneys as a term of art, big thing with lawyers, that had meant anew. Let's use an example that may arise in a criminal case. You have been accused of some heinous crime, perhaps like Reuben Hurricane Carter, represented by the attorney for whom I served as child protege, who had been accused of a multiple murder in Patterson, New Jersey. Promising career as a boxer, suddenly taken to a halt because of being in the wrong place at the wrong time. But his claim was that the police had arrested the wrong person. Is that a matter of fact or a matter of law? Think about it. Wrong person. Is that a law? Is that a fact? If you get that wrong, forget about law school. Another example from history with which most may be relatively familiar. In his letter from a Birmingham jail, Reverend Martin Luther King Jr., friend of my father, wrote a rather well-developed statement regarding the distinction of what attorneys would describe as being between facial challenges and as applied challenges in the courts. When he wrote, there were some instances when a law, hint, hint, is just on its face, hint, hint, and unjust in its application, hint, hint. For instance, I was arrested Friday on a charge of parading without a permit. Now, there is nothing wrong with an ordinance which requires a permit for a parade. But when the ordinance is used to preserve segregation and to deny citizens the First Amendment privilege of peaceful assembly and peaceful protest, then it becomes unjust. Truly a question of law, right? And so by the rule, we then know that the appellate court is not interested in what your attorney trying the case all over again, what Dr. King wore to the parade, what he ate for breakfast, but simply interested in determining, in Reverend King's example, as to whether the application in that as-applied challenge is directed at an illegitimate purpose or being applied in an unconstitutional way. And for those further interested in standards for completely repealing a law, we want to get rid of this. In 1987, the U.S. Supreme Court presented a bright line rule to make it very, very Sesame Street simple, easy to understand. And if you can't understand it, then again, stay away from law school. And setting a very, very high bar to overcome, because a statute will, and also stay away from legal discussions, because a statute will sustain a facial challenge unless, and this is a quote, no circumstances exist under which the act would be valid. What is that? That's a categorical argument, isn't it? No exceptions. no set of circumstances, and if there is even just one, you will lose against the government in court. Categorical arguments, you did take. Logic might be important if you're going to study law. And these are basic concepts that a first-year law student should understand, at least at a Tier 1 law school, by the completion of that year of study. But the average person who may encounter a legal problem, as Pastor Jacobson had done when the city of Cambridge, Massachusetts, had imposed a $5 fine against him for refusing to submit to a smallpox vaccine mandate, are not as familiar with the law as even a first-year law student. And believe you me, first-year law students have a difficult time trying to understand a lot of this stuff being pumped at them fire hose style. And this is why we generally, and they go out and get study groups and do outlines and other stuff that I did not do. And this is why we generally say that only a fool attempts to represent himself in court. But it is this very issue that is the gravamen of our case at the United States Supreme Court for oral argument, because even legal scholars like Richard Posner, a name that you'll know if you go to law school, a lecturer at the University of Chicago Law School and former Seventh Circuit judge who had been appointed by Ronald Reagan, has expressed great concerns about the mistreatment of persons who take the chance to try a case, criminal or civil. A lot of criminal cases. 70% of your pro se litigation without the assistance of an attorney to develop and argue their case. Why are you going to go into court facing possible criminal charges without an attorney? A lot of reasons, but that's the way it is. Pastor Jacobson did recognize that he was not smart enough about the law in even a misdemeanor case to fight a vaccine mandate. And so he chose to retain two attorneys, Messengers Frederick H. Nash and Herbert Parker, for defendant in error, who managed to lose his case all the way to the Supreme Court, but were granted certiorari and had the chance to deliver oral argument, as we shall be doing very, very soon. But there were some very serious questions about whether Pastor Jacobson had performed any due diligence before retaining his attorneys. Just got his stupid brother-in-law, went to night school. Whether they had provided competent representation, or another possibility. There's always another possibility. If you're not thinking about possibilities, you're not thinking like a lawyer. Pastor Jacobson, let's say, took a very involved role in his defense, was a very, very dominant kind of take charge, type A personality man, and told the attorneys the legal arguments that he would permit them to bring if they were being paid from his pocket, which makes one wonder why he decided to pay them at all and not just represent himself. Delegation, very, very important in leadership. Learn how to delegate. You can't do it, then find somebody who can and let them do it for you. But before we proceed further into the issues to be decided in our case before the Supreme Court, perhaps a little more review of the fundamentals is required to understand the complexities of the judicial system and why for probably most litigants, an attorney, especially the right to an attorney, is a very important decision that should not be taken lightly. Here's a familiar phrase. You have a right to remain silent. Dun, 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 dun. Jeopardy question. It might be fair to assume that probably most Americans have some familiarity or even acquaintance with this phrase from a television cop show or even movies, and may also be able to recite at least one name in the U.S. Supreme Court case from which we developed the law enforcement procedure of being administered Miranda warning rights, Miranda rights warning prior to arrest. What is the procedure? I can set it off. For those who believe there is actually an amendment in the Bill of Rights, as much as the attorneys for Reverend Henning Jacobson believed all the way to the U.S. Supreme Court, or at least argued that there might be rights guaranteed by the preamble, for your greater edification and to keep you from looking stupid on Facebook or someplace else where you might embarrass yourself, please permit me to disabuse you of that farcical notion for these statements that an accused will here upon arrest find their origins in actually a collection of cases that were brought before and decided collectively by the nation's highest court in 1966 under the collective caption Miranda v. Arizona. Interesting cases. I would really recommend reading that case, especially if you want to know about Mutton Jeff and a lot of things that happen when you're in interrogation. But here's the test question. Is there an amendment to the Constitution from which the right to remain silent is derived? Well, if you've watched some crime shows or attorney shows on television, you know that when you get in trouble with the law, then you can lawyer up and take the Fifth, which we should know is a reference to what? The Fifth Amendment, which in relevant part provides that no person, this is a quote, no person shall be compelled in any criminal case to be a witness against himself, right against self-incrimination. You'll hear that a lot. But what you may not know is that if you are apprehended by the local police or even the state police or the county sheriff, it generally will not be the Fifth Amendment that will actually apply to your situation. Because it's not federal, it's not the FBI, it's not the DEA, but rather the 14th Amendment, which was adopted after the war between the states. You don't like that phrase? Take another course, and which extended the protections embodied in the Bill of Rights to the separate and several states. But who wants to say you can take the 14th? If only because, to an educated person, that could mean just about anything. And with a total of 10 amendments in the Bill of Rights representing quite a large bundle of rights to be included. So you could basically mean anything. Now, just a quick test of the material. Do you have the right to remain silent in a civil case under the Fifth Amendment? Think about it. Well, let's begin with a case that we shall be using in this video series to explain why we are now docketed for oral argument at the Supreme Court, having defied the incredible odds that only 6% of attorneys do in almost 6,000 petitions filed every year for certiorari to the United States Supreme Court, Jacobson v. Massachusetts. When you read, and you're encouraged to read cases. The first paragraph from this decision, especially in pandemic, very important case to note, that has been repeatedly referenced by courts and legal scholars in the current public health crisis, you should get a sense that Justice Harlan is not exactly pleased and is exercising his supervisory powers. And you almost expect to hear Pastor Jacobson's attorneys telling the court that they know it looks bad, but they can explain this, which is never a good way to begin a meeting, especially not in court. In the very first paragraph, Justin Harlan says to history, I don't want to be this guy, we pass without extended discussion the suggestion that the particular section of the statute of Massachusetts now in question, 137, chapter 75, is in derogation of rights secured by the preamble of the Constitution of the United States. Although that preamble indicates the general purposes for which the people ordained and established the Constitution, and please do not start singing, it has never been regarded as the source of any substantive power conferred on the government of the United States or on any of its departments. Such powers embrace only those expressly granted in the body of the Constitution, and such as may be implied from those so granted. Although, therefore, one of the declared objects of the Constitution was to secure the blessings of liberty to all under the sovereign jurisdiction and authority of the United States, no power can be exerted to that end by the United States unless, apart from the preamble, it be found in some express delegation of power, or in some power to be properly implied therefrom. I mean, that's a bad meaning. That's a bad first day of class at law school when you discover that it was your duty to read the syllabus that was posted on the bulletin board to complete the reading required for the very first day of class. In law school, unlike you may have found in college or high school or grammar school, the first day of class is not general introduction to kindergarten, where your professor says hello, maybe tells some jokes, lets you play some games, and keeps it pretty pleasant and entertaining. Not in law school. Not in law school. And you don't want to be the law student who didn't watch the paper chase and did not know, being asked to brief the facts and procedural history of a case that you did not know you were supposed to have read the homework before you came to class the night before. So, another test. If all powers and rights are based upon some express source of law apart from the preamble, when you read the Fifth Amendment, where it states that no person shall be compelled in any criminal case, stomp, foot, to be a witness against himself, does that expressly say that it applies to a civil case? Well, if it is not in the contract, then you can't do it. Easy rule. Move on. But how about the next phrase in the standard Miranda rights warning? You have the right to an attorney. If you cannot afford an attorney, then one will be appointed for you by the court. Do you understand? Just like the old game show, Name That Tune. Can you name that amendment specifically? Don't say the Fifth Amendment. And if you said the Sixth Amendment, you would be correct, because in relevant part, it provides that in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. So, in the Sixth Amendment, do you have a guarantee to be provided assistance from an attorney in a civil case? In a civil case, do you have a guarantee to be provided assistance from an attorney? No, you do not. Did you see civil case? No, you did not. But if you are in a civil case and say that you decide to sue someone like the pharmaceutical companies or the government, the phone company, do you think that they are going to send a lawyer, or maybe even several lawyers, high-paid lawyers in nice fancy suits, to court to defend themselves against you? Do you believe that they are going to be nice to you just because you don't have an attorney? Come back from Disneyland. Because as Mom used to say, you let your big mouth cash a check that your little brown bottom can't cover, unless you have done your homework and are prepared for class. Go up to those guys from the Brooks Brothers suits and say, bring it on, mofo. You really don't want to see a first paragraph in your case that reads like the one in Jacobson v. Massachusetts for everyone to read forever, even after you are gone, and ask, why did that crazy fool make that wholly ludicrous argument in court? Derogated rights under the preamble. What was he thinking? But nonetheless, Pastor Jacobson got his case all the way to the Supreme Court to make that silly argument. And in the next series, in a little continuing legal education, CLE, attorneys say, but for non-attorneys, let's have a little discussion, or maybe for some attorneys, because I've seen some attorneys that might require this CLE. Let's have a little discussion about the requirements for a grant of certiorari and how an argument about derogated rights might still be a good enough argument to succeed of being heard before the nation's highest tribunal as we review the rules, which is what you actually have to do in due diligence preparation before you get the crazy notion in your head to say you will take your case all the way to the Supreme Court, if necessary. Even if it sounds very, very good on television, your publicist told you to say it, just sounds good in your head because you saw it in a movie and always wanted to say that. Don't tell me your friends always thought you would be a great attorney because you always have an argument. Your friends said you should run for Congress because you have a lot of opinions. Your mama said you could sing, so you joined the church choir. What can I say? Don't believe everything your friends and family tell you, because they may just be trying to be nice to you and really don't want to hurt your feelings. They realize how sensitive you are. This briefing is unclassified, as you will. My name is Major Mike Webb, and by God, I am running I did run for Arlington Public School Board, and also ran to the sound of the guns to catch a novel coronavirus in court. And we've always got them. So let's keep Mike Webb away from our schools. honest. Carry on. This advertisement was authorized by Mike Webb.
Thunk, I could have had a vaccine.